Good morning, everyone. This is Joseph Maestas, Chair of the Public Regulation Commission. It's 9:30. I am here in the Public Regulation Commission's hearing room. I'm joined by, is there an echo? Commissioner Byrd is with me. John Reynolds is also with me, and my assistant, Christopher Hall. So welcome everyone to the Public Regulation Commission's regular weekly meeting. I'd like to call this meeting to order. Russell?
Yes, Mr. Chairman.
Are you in for Mike Smith? I know Mike's on the
Yes.
call, but
Yes, I am. I can take the roll if you would like.
yes, take the roll.
Commissioner Hall. I'll go back to Commissioner Hall. Commissioner Basenti Aguilar.
Here.
Commissioner Fishman. Commissioner Maestas.
Here,
And Commissioner Byrd. Commissioner Byrd, you may be, I don't hear Commissioner Byrd, but I know he's there. I see.
Russell, I'm here. This is Commissioner Hall. I accidentally kicked myself out.
Okay. And Commissioner Byrd, is
Present.
Commissioner, yeah, okay, thank you. Now let me try Commissioner Fishman one more time. Commissioner Fishman. Okay, well, Mr. Chairman, we have 4 commissioners present and 1 absent, so we have a quorum if you would like to proceed.
thank you. Commissioner Hall, do you mind reciting the Pledge of Allegiance and the State Pledge?
No, I'd be pleased. I pledge allegiance to the flag of the United States of America and to the republic from which it came, one nation under God, indivisible, with liberty and justice for all. I salute the flag of the state of New Mexico, the Zia symbol of perfect friendship among united cultures.
Thank you, Commissioner Hall. Members of the commission, you have the agenda before you. I know we have at least 1 amendment, and it's under utility matters. In the case of 19-106-UT, we will be deferring action on that until next week. And let me just read the caption. It's in the matter of applications for the 2020 broadband program support from the State Rural Universal Service Fund as per 17.11.10.31 NMAC. Are there any other amendments to the agenda?
Mr. Chair.
Commissioner Byrd.
Thank you. One other change. Conveniently, the House convened this morning at 9 a.m. And so our comment from Representative Jim Townsend, he's not going to be able to make it. He texted me at 7:30. So that's off. Thank you.
Okay, so we will not have public comments from Representative Townsend. Any other changes to the agenda? All right, hearing none, do I hear a motion to approve the agenda as amended?
Moved.
Okay, we have a motion by Vice Chair Hall and a second by Commissioner Byrd. Any discussion on the motion? Russell, take the roll call vote, please.
Yes, Mr. Chairman. Commissioner Byrd.
Aye.
Commissioner Fishman.
Aye.
Yes, Commissioner Basenti Aguilar.
Aye.
Commissioner Hall.
Aye.
And Commissioner Maestas.
Aye.
The agenda as amended is approved 5-0.
Okay, and I understand there is no public comment, nor do we have any special guests. Is that true, Sarah?
That's correct, Mr. Chair.
All right, so let's go ahead and move on to item 6, consideration and approval of prior meeting minutes. Do I hear a motion to approve the minutes of the January 19th, 2022 open meeting and the same for the January 26th, 2022 open meeting.
Mr. Chair,
Yes, Commissioner Byrd.
I need to just point out to Mr. Boaz on the minutes of January 26th, throughout the text or the body of the minutes, the word counselor was used in place of commissioner. Nothing substantive, obviously, just a correction in terms. That's it. I will approve the minutes as amended.
Okay, we have a motion to approve the minutes as amended. Do I hear a second?
Second.
Second by Vice Chair Hall. Any discussion on the motion? Russell, please take the roll.
Commissioner Fishman,
Aye.
Commissioner Maestas,
Aye.
Commissioner Hall,
Aye.
Commissioner Vicente Aguilar,
Aye.
and Commissioner Byrd.
Aye.
The minutes with those amendments are approved 5-0.
Thank you, Russell. Let's move on to consent agenda. We had obviously one change. But before I ask Russell to read the captions of the consent agenda, I'd like to entertain a motion to approve and a second. Anyone?
Move.
All
To
right,
approve.
we have a motion by Commissioner Fishman. Do I hear a second?
Second.
Second.
Second by Commissioner Byrd. All right, before I entertain any discussion, Russell, do you mind reading the captions of the consent agenda items?
Yes, Mr. Chairman. The first item is docket number 22-00004-TR-M.
Betty, or are you just teasing me?
That's in the matter of the application of M Mountain Transportation LLC for a certificate to provide non-emergency medical transport service. The second item is 22-00010-TR-M in the matter of the application of BRT Enterprises LLC, DBA Blue Raven Transport, for a certificate to provide non-emergency medical transport service. And then the item number 3, the utility matters was removed. That's 19-106. So we go on to 21-00188-UT in the matter of the joint application of AV Water Company LLC and New Mexico Water Service Company for the several approvals and authorizations required in connection with the acquisition of AV Water Company LLC's assets by New Mexico Water Service Company and the application by New Mexico Water Service Company for approval to operate certain water utility facilities. That is all of the consent action agenda items.
Thank you, Russell. So we have a motion and a second. Do I hear any discussion regarding the consent agenda as amended? All right, Russell, please take the roll.
Commissioner Vicente Aguilar,
Aye.
Commissioner Byrd,
Aye.
Commissioner Hall,
Aye.
Commissioner Maestas,
Aye.
and Commissioner Fishman. Commissioner Fishman, you may be muted.
Aye.
All right, Mr. Chairman, the vote to approve the consent action agenda items as amended is unanimous 5-0 to approve.
Okay, the next item on the agenda is executive closed session. Deliberations regarding docket 20-238-UT in the matter of Southwestern Public Service Company's application for revision of its retail rates under advice notice number 292. Number 2, authorization and approval to abandon its Plant X Unit 3 generating station and other associated relief. But before we go into closed session, I would prefer that that we let the public know why this item is on the agenda. And perhaps Judy, if you can just talk about the developments. I think there's some
Yes.
orders.
Yes, Mr. Chair. This matter comes before you today
upon a filed emergency request for a final order, which was filed by SPS on February 10th, 2022. In that request, emergency request, SPS asked the commission to issue a final order in this docket and provided their suggested two options. First, option one would be to adopt the rates set forth in the February 2nd, 2022 order adopting certification of stipulation with modification. Or two, a motion to reconsider that February 2nd order and accept the certification of stipulation in its entirety. In addition, on the day prior to filing that emergency request, on February 9th, 2022, all the signatories to the stipulation filed a response, which stated that it was this, the signatories did not unanimously accept the commission's proposed modification to the stipulation as presented in the commission's order dated February 2nd, 2022, decretal paragraph B. So based upon those two filings, this matter is being brought before you today to consider SPS's two options, as well as there are two other options that were proposed by Commissioner Fishman, and I can go through them now, or I can wait.
Briefly, just briefly, if you could, Judy.
Option number three, proposed by Commissioner Fishman, would deny the motion for reconsideration, but provide the parties with an additional week or two to unanimously agree to the modifications made in the February 2nd, 2022 order. Option four would continue with the February 2nd order to proceed with a pre-stipulation litigated track. In addition, the commission would need additional time to consider the merits, and for that reason, the option number four order would extend the suspension period for an additional 3 months. It would commence on a date as determined by the hearing examiner. However, the order does state that the tolling was lifted as of February 9th, 2022. The hearing examiner would issue a procedural order for further proceedings to include a public hearing with dates for filing supplemental testimony. In addition, it would direct the hearing examiner to order the filing of supplemental testimony on the issue of rate shock and gradualism generally and as applied in this case, and any proposals to avoid it. It would direct the hearing examiner to have SPS, the Attorney General, and Occidental file supplemental testimony discussing any existing alternative cost allocation schemes that do not depend on load factors and that are currently implemented in other jurisdictions. Additionally, supplemental testimony shall include recommendations for a process to determine an updated cost allocation methodology for SPS's next rate case. SPS shall and any other party may file testimony discussing how load factors should be applied to Sagamore and Hale. Also, subsequent to the filing of the e-agenda and the memo and the proposed orders, Commissioner Fishman suggested that options number 3 and 4 could be combined. So essentially, it would be option 5, combining option 3 and 4, which would provide the parties with an additional week or two to agree to the modifications made to the stipulation on February 2nd. So basically, provide additional time to negotiate, and at the same time, allow the case to continue to proceed on the pre-stipulation litigated track, and in addition, add the 3 months to the suspension period. So I know that's a lot to digest, but that's basically the options in a nutshell.
Thank you, Judy.
Mr. Chair?
Yes, Commissioner Fishman.
Yeah, I had put the executive closed session on the agenda in case we needed it. I'm not sure that we do, but I'll let the other commissioners weigh in on that.
Commissioner Fishman, better yet, why don't we just ask Officer General Counsel? We have certainly more orders to consider, Judy, in this. And I know that, you and the rest of the OGC staff get uneasy when we're talking about the content of these orders, which are protected by attorney-client privilege. So what is your recommendation? Do you recommend we go into executive closed session?
I would state that if the commission is just going to make a motion now and pass it one way or the other on a particular order, that we don't need to go into executive session. However, if the commission would like to have a more in detail conversation, there is potential litigation that the commission could be involved in the future. And therefore, I would recommend, if you are going to have continued discussion, that we go into executive session. One other thing I'd like to add is that I believe it was on Monday, the New Mexico Large Customer Group filed a pleading in response to SPS's motion, are urging the commission not to adopt SPS's option 1, and because it would deprive them of procedural due process. And they made many other arguments, and we can discuss it in further, but I wanted to mention that.
Mr. Chair,
Yes, Vice Chair Hall.
I would prefer we go into closed session. I think it's just better. I think there's probably a lot to discuss.
All right, do you want to make that in the form of a motion, Vice Chair Hall?
Yes, I'll move we go into executive closed session.
Okay, Russell, do we need to read the caption again? Russell Fisk?
Sorry, I was muted. Sorry about that. I don't believe they should read the caption. There will have to be a roll call vote and a second to the motion. And I believe then, Mr. Chairman, you would, before going into the closed session, you would announce that you're going to closed session and cite the statutory section that's cited in the agenda. I think we need a second, and then I can take the roll call.
Okay, do I hear a second? We have a motion on the floor to go into executive session, deliberations by a public body pursuant to 10-15-1, Prin H, Prin 3, NMSA 1978. Do I hear a second? Second by Commissioner Fishman. Well, there's no discussion. Roll call vote. Russell.
Commissioner Maestas.
Aye.
Commissioner Fishman.
Aye.
Commissioner Vicente Aguilar.
No.
Commissioner Byrd.
Aye.
And Commissioner Hall.
Aye.
Mr. Chairman, the vote is 4-1 to go into executive closed session.
Okay, all right. We are in executive session. Do we go to a separate room? Isaac or Russell?
Mr. Chair, this is
Yes.
Sarah. Hi, I have you guys all set up to go into closed session, so I will send you now.
Okay, thank you.
Um,
Are we all back?
I'm here.
Joe, if you're talking, we can't hear you.
Looks like the hearing room Zoom connection got muted somehow. I think it might automatically mute people when it sends them back from the closed session into the main session.
Okay, you should be able to hear us now.
We can.
Yes.
Okay.
All right, so we have a motion on this and a second to come out of closed session and back into open session. Russell, please take the roll.
Mr. Chairman, it's Michael Smith. The motion and second should be made on the record in open session.
It was made openly between us.
Yeah, unfortunately, we couldn't hear
Why
you.
don't you make it?
Right, so I'll remake the motion. I move that we leave closed session and return to open session.
We have a motion on the floor by Vice Chair Hall. Do I hear a second? I'll second it.
Okay.
All right, and we had a little closed session within the closed session. Sorry about that. Russell, please take the roll.
Commissioner Hall,
Aye.
Commissioner Vicente Aguilar,
Aye.
Commissioner Fishman,
Aye.
Commissioner Maestas,
Aye.
and Commissioner Byrd.
Aye.
The motion to come back out of closed session into open session passes unanimously, 5-0. And Mr. Chairman, I believe you need to affirm that there were only matters discussed in closed session that were pursuant to the cited statutory section on the agenda.
Thank you, Russell. Yes, the discussion was limited to the subject matter outlined on the agenda and no decisions were made. All right, let's move on. Sarah, if you could highlight case 20-238-UT. All right, members of the commission, you have a multitude of potential orders. Do you have any other general questions or do you wish to make a motion regarding any one of the optional orders? We have options 1, 2, 3, and 4, and then an option number 5 that seeks to combine options 3 and 4.
Mr. Chair,
Commissioner Vicente Aguilar.
Thank you, Mr. Chairman. I would like to make a motion to reconsider the order and accepting the certificate of stipulation in its entirety. That's my motion, Mr. Chairman.
Okay, we have a motion on the floor, but just to be clear, this would be option number 2 order. So we have a motion by Commissioner Vicente Aguilar. Do I hear a second?
I'll second.
Okay, a second by Commissioner Byrd. Any discussion on the motion? Again, the motion is to adopt the order regarding option 2, which is a motion to reconsider and to accept the stipulated agreement. Any discussion on the motion? Russell, please take the roll.
Commissioner Byrd,
Aye.
Commissioner Fishman.
No.
Commissioner Vicente Aguilar,
Aye.
Commissioner Hall,
no.
and Commissioner Maestas.
Aye.
The motion passes 3-2.
All right, thank you. And thank you, Commissioner Fishman, for that excellent dialogue about the rates. All
Mr.
right,
Chair,
yes,
while we're on this, so what I said in closed session, I want to say in public that I believe Commissioner Fishman's heart is in the right position, and I am aligned with him in that. I think that the ratepayers and those responsible for looking out for ratepayers should look into what Commissioner Fishman has said and what he's proposing, and try to implement these beliefs, this standard for ratepayers. We should be looking out for them. That's one of our goals. It's not our main goal. It's one of our goals. And we need a record developed to support that. And so anyway, I thank you, Commissioner Fishman, for bringing it to light, making it a discussion item, and hopefully we will see fruit from your efforts. Thank you, Mr. Chair.
thank you, Commissioner Byrd. Let's go ahead and move on.
Mr. Chair, Mr. Chair.
Yes, Vice Chair Hall.
So I would also like to comment that I think that a big problem I have had with this case is that it's a black box settlement. And the result of it was, as Commissioner Byrd mentioned, not satisfactory for the residential ratepayers in that area. And I just wanted to express my strong concern about black box settlements. I know parties like them. I think they're quite appropriate in maybe non-regulated life, but before the commission, where we have so many considerations to take into account in trying to provide a balance between the interests of the ratepayers and utilities, we need transparency. So I strongly feel that we need to do something to be able to be free to look into these agreements, or just outright ban them from being used before the commission, because I don't think it's appropriate in the regulated realm, at least in our regulated realm. So I just want to make that statement.
Thank you, Vice Chair Hall. I guess now you're kind of goading me into commenting on this, but whenever I read, the recommended decision in a stipulated agreement, I recall the phrase that says that we're not really concerned how we arrived at this stipulation. It's that the stipulation was achieved, that avoided protracted adjudication and potential litigation, which I think should be a consideration by this agency, is to avert and prevent a full-blown litigation through alternate dispute resolution techniques, whether it's mediation, binding arbitration, or stipulated agreements. But Judy, if you could just weigh in briefly on that notion. Is that statement based on any kind of case law? The statement that we need not be too concerned with the method that led to a stipulated agreement. It's that we've arrived at a stipulated agreement. Can you address that, Judy?
Yes, well, there are 3 factors that the commission looks at when adopting a certification of stipulation. And now I'm going to speak off the top of my head on the 3 factors, but they are that it's a result of arm's length negotiation, that it results in fair, just, and reasonable rates. And there's a 3rd one that I can look up. That being said, the commission also and the U.S. Supreme Court has affirmed the principle of the end result. And it's the end result, as long as that it results in fair, just, and reasonable rates. You don't necessarily have to have a specific methodology as long as the end result results in fair, just, and reasonable rates. And as I stated on February 2nd, the certification of stipulation did pass the three-prong test. And, while it's not perfect, it did result in, and it was testified to by all of the parties, that it resulted in fair, just, and reasonable rates.
Mr. Chair.
Hold on, Vice Chair Hall. So Judy, there's no express or explicit prohibition to such a black box settlement. I realize the term, the adjective has connotations, but there's no explicit prohibition in terms of not just commission practice, but industry practice.
In terms, I don't feel comfortable talking about industry practice. In terms of practice before the commission has in the past approved number of black box settlements. This stipulation is not entirely black box. There are portions of it that are black box. In other words, we don't know exactly how the final revenue requirement was agreed upon, which went down from approximately 85 million to approximately 62 million. But we do know a lot of the terms in terms of a lot of the credits that SPS agreed to provide. And in terms of the rate allocation, which has been a hotly contested issue here, we do know that that is not black box. So yes, we have the authority to approve black box settlements. It's happened before, but we also have the authority to, in the future, say we don't want to approve those. So right now, that's something for the commission to consider, and they could do, they could change their previous policy by changing our procedural rules.
Okay.
By the way, I had some assistance from Elizabeth, who reminded me that the third prong that was satisfied was that the parties were they were all represented by legal counsel. They were all very knowledgeable in the utility industry. They were, and so that's the third prong. And they satisfied all those prongs. That being said, again, black box stipulations are something the commission has approved before, but the commission could decide that they do not want to do that in the future.
Okay, thank you, Judy. Vice Chair Hall, and then Commissioner Fishman.
Thank you.
Mr. Chair, I just wanted to state that I appreciate how Judy is describing this. My concern is whether or not we can actually determine whether the rates are fair, just, and reasonable. When you have such a disparity, as we have in this case, between what the residential ratepayers would pay compared to all the other groups of ratepayers, all the other classes, it raises a question in my mind whether or not justice is done, whether or not these are really truly just rates. And I know there were provisions made wherein the company agreed to a very large reduction in revenue requirement. So, and that would not be preserved in any other way, apparently, unless we were to go to litigation. But I would have been much more happy if we could have been able to look into the case and determine whether or not that reduction in revenue requirements would have resulted in enough of a decrease in bill impact to be comparable to what I think otherwise would have been a just allocation of rates for the residential class. But we're not able to, we can't see that. So my beef with these black box agreements is that, unlike in the ordinary private sector of litigation, where parties, the agreements between private parties only have bearing on their own lives. Unlike that, the agreements between the parties to a stipulation before us have bearing on many, many, many other people's lives. And in that sense, I am not confident that those people have a voice when we have an agreement like this. And so that's why we commissioners need to be able to see into the decisions that were made in order to represent those people whom I find it difficult to believe are all being represented by one other lawyer in the room. So that's just my deeper dive into that. I think in particular, if I've been able to see this particular information to see whether or not the two deals were actually somehow comparable, I might have felt a little better about it. But with the end result, I still think that this is not just. So anyhow, I'll stop now.
Vice Chair Hall, Commissioner Fishman.
Yeah, just real quickly. Thank you, Commissioner Byrd, for at least recognizing the legitimacy of the issues I was raising. So I appreciate that, even if we disagreed on the vote. And just a quick comment. I agree with Commissioner Hall on the fact that I have a transparency issue when we do these black box settlements. And that if you're not looking at, if you don't have a clear record of how you got to where you were in the numbers, you don't have any touchstone to gauge whether what you did was actually fair, just, and reasonable. And I think all of that should be transparent. But the core, and just one further comment, is the core idea that somehow a black box settlement saves time by saving litigation, I believe is untrue. I think what it does is it kicks the issues that were not settled down the road to the next case, next rate case, and the litigants end up debating them all over again until they come back to a settlement and kick it down the road again. And then at some point, they finally get litigated. So I think the premise that in the long run, that stipulations save time is false. I think in practice, they actually end up eating up more time and resources because you keep revisiting the issues instead of settling them. So that's my comment on that. Thank you.
Thank you, Commissioner Fishman. All right, let's move on to the next agenda item. It's in the case of 20-175-UT in the matter of potential amendments to NMPRC Rule 17.9.570 NMAC entitled Governing Cogeneration and Small Power Production. Judy Amer, you going to tee this up for us?
Yes, Mr. Chair, members of the commission. You may recollect that on our first meeting of the year, January 5th, 2022, we discussed an update on the amendments to be made to NMPRC Rule 17.9.570, which you read the title, but it relates to PURPA and FERC's changed regulations pertaining to PURPA. And this also relates to litigation that the commission was involved in, which I won't go over again. What is coming before you today is a motion that was filed by El Paso Electric to reopen the record for additional comments. They would like to file comments that would address some of the comments made by the commissioners during the January 5th, 2022 meeting. There's two areas that, and attached to their motion was Exhibit 1, which were their comments. This order would allow the filing of the comments and would keep the record open for 10 business days so that other parties could file additional comments relating to the comments made at the January 5th open meeting, and that all of these new comments would become part of the rulemaking record. There's two areas that EPE's comments address. First, regarding the community solar implication of the PURPA rule, EPE states that Rule 570 is not implicated in the community solar context because the Community Solar Act itself requires New Mexico utilities to interconnect with community solar facilities and to purchase their output, and requires, and if the PURPA rule required subscribers under the Community Solar Act to be QFs, that would needlessly complicate the calculation of the community solar bill credit, because under the PURPA rule 570, QFs are paid avoided costs, but the Community Solar Act requires the utility to pay avoided costs only for unsubscribed energy. For subscribed energy, the Community Solar Act requires the utility to provide the subscriber with what is entitled a community solar bill credit. That's their first comment. And then their second comment has to do with the discussion between whether avoided costs should be variable or fixed. And you might recollect that developers of QFs are proponents of fixed costs and what they say a predictable revenue stream, because they have argued that they're unable to obtain financing. However, EPE's motion points out that FERC, specifically in order number 872, stated that QFs have no right to guaranteed financing under PURPA. And I quote, FERC agrees with commenters that PURPA does not guarantee QFs a rate that guarantees financing. PURPA only requires FERC to adopt rules that encourage the development of QFs. It does not provide a guarantee that any particular QF will be developed or profitable. The legislative history confirms that Congress did not intend to guarantee QF financing. In addition, FERC said QFs don't need fixed energy to obtain financing. And again, quoting FERC, the record shows, and this is the record in their rulemaking, their amended rule that we're amending our rule to comply with. They said, the record shows that even without the right to require long-term fixed energy rates, non-QF independent power producers nevertheless have been able to obtain financing for large amounts of generation capacity, including from renewables. Based on this data, we find that the right to require counterparties to pay fixed energy rates is not essential for the financing of independent power capacity. And that's just some of the highlights of their Exhibit 1. They made other comments that allowing a QF to lock in a fixed energy price that exceeded the market cost would harm customers because they would be forced to subsidize QFs, which would violate PURPA. And regarding the fact that, QF, some developers have argued that sometimes the fixed price will be above market price, sometimes it'll be below market price, which evens out. FERC specifically found, according to EPE, that the over and under have not balanced out, and customers have overpaid for energy and subsidized QF. So I stand for questions. As I said before, the order would reopen the record for 10 business days to allow further comments to be filed, and then it would be closed.
Thanks, Judy. So what you have before you, commissioners, an order granting EPE's motion to reopen the record for additional comments. Any other questions for Judy? If not, do I hear a motion to approve the order as presented?
So moved.
Second.
Okay, we have a motion by Vice Chair Hall, a second by Commissioner Byrd. Any discussion on the motion? All right, Russell, please take the roll.
Commissioner Fishman,
Aye.
Commissioner Maestas,
Aye.
Commissioner Hall,
Aye.
Commissioner Vicente Aguilar,
Aye.
and Commissioner Byrd.
Aye.
Mr. Chairman, the motion to approve the order presented by OGC is adopted 5-0.
Thank you, Russell. Let's move on to the next agenda item. It's regarding case 21-215-UT in the matter of the Public Service Company of New Mexico's request for approval of new resources under 17.9.551 NMAC to replace 114 megawatts of leased Palo Verde nuclear generating station capacity. Michael Smith, so you do have an order as well, correct?
Yes, Mr. Chairman, I apologize. I sent that out at a early or a late, rather, I should say, opportunity this morning, early this morning. What we have on the agenda is an order that would address the replacement resources portion of the application by PNM. However, before the commission considers that, I did discuss this with the hearing examiner, and he is available, and I think he's present rather, to present his recommended decision to the commission. As you know, it was issued on shortly after midnight between Sunday and Monday morning. And given the urgency of getting these resources approved so that PNM can move to get them online, I modified the procedural schedule for exceptions, and the parties indicated that the parties that responded indicated that they did not oppose the commission addressing the request for replacement resources separately from the other issues that were addressed in the recommended decision. So I think it's appropriate if Mr. Ryan can present his recommended decision. I think he can present the entire recommended decision if he is able to do so. And then we would be able to move on to address the remaining issues in this case pursuant to the normal commission procedure for consideration of any exceptions the parties might have to those remaining issues. So by way of that, with background, I would turn it over to Mr. Ryan.
And before we do that, Michael Smith, is there a deadline for us to act?
Mr. Chairman, yes, that was the reason that we were also moving quickly on this is the 6-month period for consideration and approval of a request for approval of a purchase power agreement is calculated to end on February 25th. And that's the reason why we have this on the agenda today, is so that the commission can take action on that unopposed portion of the recommended decision prior to the expiration of that time. The other issues that are in that case are not subject to the rule, because it only addresses the request for replacement resources.
Thank you, Michael. Although we didn't specifically list the presentation of the recommended decision, is it your opinion that we can do that despite not listing that on the agenda?
Mr. Chairman, Commissioners, yes, I think we can. We have this down as a discussion, and I believe that it's appropriate for the hearing examiner as part of that discussion to discuss his recommended decision.
Okay, any other procedural questions or general questions on the part of the commission for Michael Smith before we have the hearing examiner present his recommended decision? Any questions or comments? Okay.
Good morning, Chairman and Commissioners. I'm going to start with this presentation talking not about the recommended decision, but the decision I made to not initially and subsequent to a motion for reconsideration permit a further bifurcation of this matter to have a summary procedure to approve the proposed resources. I understand there is questions relating to why it is that I did that. And I wish to be as clear as I can with the commission as to what the basis for that decision was. PNM presented testimony and then also referenced in its motion for reconsideration of the decision not to have a summary procedure about the proposed resources, a timeline about when NMPRC approval was required in order to have a non-appealable approval date for each particular resource proposed here. As you can see, that chart is just presented on the screen as it was presented to me in both testimony and in post-hearing motions. What you should know, when cases are initiated and procedural orders are issued, it very much is a sort of chess game that is set up. Selecting one particular date dictates what shall happen down the line. So based on initial hearing dates proposed in this case, the simple math is that this matter would not be before this commission until January 24, 2022. Now, why is that? If that's after the date at which PNM has represented it requires non-appealable approval date to have a non-appealable approval date. Well, the initial hearing in this case was scheduled for October 12th through 22nd. This was when this matter first appeared as 21-00083, and when this matter was a far more complicated case. There were many moving parts. And so one question you could ask yourself is, well, why would the hearing be set for October 12th through 22nd if that creates this January 24 outcome? And in case you're wondering, how do you get to January 24, 2022? I've listed that here. You pick the hearing date, right? And you can assume that won't get delayed. So we'll say there's not going to be any hearing delays. Let's assume that. You'll have, after the hearing, 20 days for initial briefs, 13 days for responses. That puts you to November 24th of 21. Third, you assume a single month for an RD. That's not realistic, but let's just assume that. Then you're at December 24, 21. You could assume further the parties are given the normal amount of time for exceptions. That's 13 days for initial exceptions and 8 days for responses. That puts you in January 14 of 2022. And then you could assume further your general counsel has 10 days to consider exceptions and prepare a final order. Perhaps that can be done faster, but that's a fair amount of time. That gets you to January 24, 2022. And you would ask yourself, well, how did that happen? Well, as we all know, there were lots of cases decided this fall, and significant ones. And if you examine the application for the merger case, the application for the Four Corners abandonment case, And then this case, this was an enormously busy period of time. And it appears the October 12th through 2022 date, the October 12th through 22 of 2021 hearing date was selected because it was the only time available and was after two other major cases had been decided. And I presume to some extent, Carolyn Glick was the hearing examiner at the time. I've never met anyone more committed to getting work done. I'm certain that that date was selected with the advice of the parties, and she was going to work as hard as humanly possible to complete it as fast as it could. But the reality was we were well into January, even from the beginning of this case. So put that aside for a moment. There are background considerations that you would not be aware of unless you participated in this case and were present for all the testimony. There is the general assertion that the interveners are all have no opposition to the proposed resources. I find that statement questionable, and I want to read for you. I mean, they are saying we don't oppose these resources, right? But they have fought tooth and nail to establish that the RFP and methodology utilized to select them are defective. Now, I will talk about that in just a second, but I want to provide you some just very minimal background. You should be seeing a PDF at this juncture. Is that correct that I've pulled up?
Yes.
Yes.
Great. So this is an exchange between Onward's counsel and PNM's vice president for generation, which I will say in the course of when you have people being very candid in a hearing, oftentimes it's very useful because you see more than you would get through pure legal argumentation. So this is an exchange highlighted that's occurring between Mr. Falgren and Mr. Throne from Onward, formerly Southwest Generation. And they're talking about the Valencia proposal in this case and what it was that PNM did with that proposal. And it's just sort of a general discussion at this point. And that's probably not enough context, but you'll just have to bear with me as I go. So Mr. Throne asks, you were asked you actually volunteered in a response to a question by Mr. Ryan, me. You talked about the fact that under the existing Valencia PPA, PNM has the right to purchase 50% of that facility. Is that correct? And then he goes on and he says, yes, sir. And then Mr. Throne says, Mr. Spurgeon actually refers in his direct testimony, Mr. Spurgeon is Onward's witness, to the fact that in 2012, is it not correct? PNM actually tried to buy 100% of the facility. And he says, Mr. Falgren in response, I wasn't employed by PNM in 2012. And Mr. Throne says, right, but that doesn't mean you don't know the answer. Do you know the answer to that question? And Mr. Falgren says, I know there's been a series of discussions over the last decade or so on various options. In effect, PNM to purchase Valencia or have some sort of agreement with Valencia for some ownership. And I'm going to skip that one part. And so then Mr. Throne says, so you don't know whether or not, in fact, the problem with the negotiations regarding Valencia was that PNM wanted the entire plant as opposed to 50% of the plant as provided in the existing Valencia PPA. And Mr. Falgren says, I can speak to the negotiations. And the next part there, the contention I had with Southwest Gen at the moment when you provided the discussions for me was that you wanted PNM to take the plant at an inflated price. And then in my 38 years, it's the only time I've been threatened where your senior vice president threatened that if I didn't take the deal, that he would send you to Santa Fe and try to muck up every proceeding we've had since then. To which Mr. Throne responds, well, I guess I'm flattered that you apparently had some conversations along those lines. I've never heard of that, but anyway, let me move on. So I want to go back to my outline here. So the other thing, and rather than reading, I think it is responsible for me to read the next one bit of testimony I'd like you to see. This was a question, an exchange between Mr. Spurgeon and I about a question about the nature of Onward's objections to the RFP and the modeling that was done here. And this question about, well, how do you say that the RFP and modeling were defective, but the resources are acceptable and should be approved. So what I say to Mr. Spurgeon is, let me ask one question before I give it back to Mr. Alvidrez. I'm just going to read here. And I say, can you address for me, and I think this is going to be a global question that I assume any commissioner would have. It just looks strange when I was sort of thinking about this over our very short lunch break. You know, the result is acceptable, but the modeling's bad. It's sort of like saying, well, the theorem for the math equation is wrong, but the answer is correct. I mean, it's just illogical. So can you resolve any doubt the commission would have? I mean, it seems to me that in order to have, if the model's bad, the results should be bad. Those two things should always go together, but we don't seem to have that here. So explain to me what the answer to that conundrum is. And Mr. Spurgeon answers, the only way we've gotten here to this point where we say these things is through this very difficult process. It's taken a lot of time to extract information through discovery that otherwise, like I say, in other jurisdictions would not be necessary. There has been a lot of back and forth. There has been this hearing to be able to get to this point. What my recommendations are focused on is not having to do this in the future, laying some ground rules up front. As I mentioned earlier, there were several issues we had with procurement that made us uncomfortable as a bidder, several facts that are established that make it difficult for a bidder to have confidence in the process. As PNM witnesses have said, reliability and the criticality of reliability are increasing over time. As future procurement happens, reliability becomes more and more important and critical. The analysis changes. We think as we head into the future procurement that getting some ground rules laid out ahead of that is important. It's hard for me to appreciate how the commission would be comfortable sitting here next year talking about a procurement case where there was issues with the RFP. There was all kinds of uncertainty about it. Bids that were bid in were not modeled. One portfolio is presented by PNM. These are the same things that happened in this case. You're looking at that down the road in a future procurement case, having that happen when the LOLE goes from a 0.2 to a 0.1, and there is a massive urgent change in need and resources as a result. Presumably, when that happens, I don't know how the commission is comfortable with RFPs that are run the same way as this one, with one resource portfolio presented for procurement. So I would ask that the commission think hard when they see arguments that this procurement, these particular resources are not opposed. Well, those statements come after what was requested to initially be a 6-day hearing, which was supposed to occur in 3, and vigorous disputes about the nature of the RFP and how that was all conducted. And so that leads me to this question, which is, how can the commission summarily approve resources from an allegedly defective process? I don't have an answer to that. And so the idea that these are not disputed, but the process through which they were selected was deficient, it makes no sense. In other cases, a defective RFP process, and let me stop sharing my screen. Well, actually, I had the right thing up now. I'm like, yes, was basis for denying the resources themselves. So I was put in a position as the hearing examiner to tell you, oh, there's this defective process, but look, we should just go ahead and summarily approve these things, and we'll just worry about the process later. That struck me, based on commission precedent, to be an untenable path forward. You had meaningful intervention, you had meaningful argument, so you have to let this play out. That was a judgment I made when I saw those arguments. And also the thing to consider is that when PNM's making the request for a perfunctory briefing schedule about resource approval, I could not know what Onward and the other veners would argue. I could assume, based on the testimony elicited at the hearing, that this is likely where they're going to go. But at the hearing, I repeatedly asked, as you saw in my exchange with Mr. Spurgeon, how is it that you can even make these arguments that the resource is acceptable, that the process is defective? And it very well may have come to pass that Onward would change a position and take some other road forward that perhaps resolves that tension. I couldn't know that at that time. And you don't know that until briefs are submitted, because all we get at a hearing is briefing, or is evidence, excuse me. And briefing is where you get legal argumentation. So you can't short circuit a system you don't actually know what will happen in, because you eliminate the possibility that something will happen that you don't expect. The next thing I want to say is, this gets to a more broader perspective about this case and more cases that I assume will come after it. Rule 551, the 6-month time limitation on commission review of procurements is outdated. I've consulted with hearing examiner Schanauer about this subject at length yesterday. That rule was drafted at a time when the complex questions related to loss of load probability analysis and the interactive effects of intermittent resources simply did not exist. And as you'll see in the recommended decision, if you've had occasion to read it, you already saw this. The testimony from the witnesses who appeared on behalf of PNM to talk about loss of load probability analysis, it is a fundamental change of the foundation of how you think about resource adequacy. A simple planning reserve margin with firm resources simply no longer cuts it. And so you have in this case where 114 megawatts is replaced by 740 megawatts. And how that is necessary is a very, very difficult and complex discussion to have. And if you've seen my recommended decision, competent counsel in this case, even counsel for PNM, said that they don't fully understand the process. It's all emerging. And so I would posit to you that our rule is entirely outdated at this juncture, and 6 months is not a sufficient time to litigate these types of cases. Much more time is needed. And that's not just for the commission staff or hearing examiners, that's for the interveners to meaningfully probe these matters so that the commission can have certainty that these resources are in fact correct. Because what we see playing out now too, and this is exactly what Onward is concerned about, the minute you add this massive amount of solar and battery, you're going to have to follow with firm resources, given the nature of the way they interact with one another. And Onward's big concern in this case is moving into a future where PNM argues that these small aeroderivative gas resources are essential in light of the fact we've added all these intermittents. This case is in every way a proxy war about that question. And part of my response in the briefing moment was to say, do I feel I should rush this? And the answer was no. Why? To be careful and prudent and to ensure someone is at least scrutinizing it. And I appreciate that the interveners indicated that they all wish these procurements to be approved, but that had to be subject to some scrutiny. And that I felt was my responsibility. And if, these last 2 points I would just make very quickly. If PNM was adamant, the ruling I made denying the request for further bifurcation and a summary procedure about approval resources was error. It had the opportunity to apply for interlocutory review. It didn't. I almost expected it would. It did not. And then I would just add to you that an RD was issued in this case as promptly as humanly possible. I was not the initial hearing examiner assigned to this case. It proceeded for 4 months before I even got it. And those 4 months were significant and effectively set the pace for all of the resource adequacy modeling questions in terms of what interveners would get for access. So it was quite the task to understand everything that occurred. I got you an RD 27 days after final briefs were filed. So I'll stop there. That's my presentation in terms of the process and why I elected to not approve PNM's request for a summary procedure to get this before you for approval. And if you wish to ask me questions on that subject, I'm happy to answer them.
Mr. Chair?
Yes, Commissioner Fishman.
Yeah, I just wanted to thank you, Christopher, for putting together some suggestions about what we need to do in terms of our rulemaking and how the issues in this case illustrate where we need to move forward in our processes and the processes that we ask you to work under. It's just terrifically helpful when you can step back look at the big picture and make those kinds of recommendations. So very much appreciated. And I just wanted to let you know that.
Thank you, Commissioner Fishman.
All right, any other questions for Mr. Ryan regarding his recommended decision?
Well, I'm just proposing, Mr. Chairman, that's really just, I understood there was meaningful questions about why I did not elect to have this get before the commission in a summary fashion faster. And so now I can talk about the recommended decision. That's what I was prepared to do next.
Christopher, I just had one question since we're experiencing delays associated with supply chain issues regarding replacement power projects for San Juan Generating Station, was there any discussion regarding that very same issue that could impact these replacement resources in this case?
Yes, that was noted in the motions that the pandemic only further, requires the commission to act as quickly as possible to approve resources and get these cases through. That was cited to me. I understood that argument. That came up in other cases I've had with PNM. It's coming up all over the place. But at the end of the day, the judgment was the commission needed to thoroughly look at this. And in order to do that, I needed time to read and prepare and craft a recommended decision.
Okay, thank you. So you wish to make additional presentation,
Chairman?
Mr. Ryan? Hold on a second. Commissioner Vicente Aguilar.
Yes, Mr. Chairman, can I ask for a break?
Sure, yeah. Let's take a 10-minute break. Well, slightly more than 10 minutes. Let's be back at 11:05. 11:05, that's a 12-minute break, 11:05. All right, thank you.
A little thinking. My victory got overturned.
You tried.
Yeah. I feel like I fought the good fight. Yeah, I should do this.
Early for that.
Well,
All right, welcome back, everyone. I'd like to resume the meeting. We are discussing case 21-215-UT in the matter of the Public Service Company of New Mexico's request for approval of new resources under 17.9.551 NMAC to replace 114 megawatts of leased Palo Verde nuclear generating station capacity. Christopher Ryan was the hearing examiner, and he is going to present a brief summary of his recommended decision in this case. Mr. Ryan.
Thank you, Mr. Chairman and Commissioners. Yes, and so just for clarification, right, the presentation I just gave you is just my explanation for how we end up in the place where we are now, why I didn't approve the summary process, and just push this forward as PNM suggested. So I'm just going to talk now briefly about the recommended decision, as I know the Commission has other matters to attend to. So I'll just share my screen again and walk through the basics of the RD. I mean, it was filed late Sunday, well, frankly, very early on Monday. So many of you have perhaps not had a chance to digest it. I can't say, but in any way, you're looking at the proposals, the Jicarilla Solar, the Jicarilla Storage, the Trisco Solar, and I'm presenting what you're seeing on screen is my recommended decision. You can see that there.
Sure, we can't see anything yet.
Oh, okay. I'm sorry. I apologize. Let me.
Oh, we can see Christopher.
My bad. Can you see that now?
Thank
you
you.
look at that PDF is up now?
Yes.
Oh, thank you. Okay, so those are the resources. Again, you're just looking at my recommended decision. This is the summary section. Those are the 5 resources that are offered to replace the 114 megawatts that will be lost in 2023 and 2024. I'm just going to scan through this. This is effectively on page 2, a chart demonstration of what you're getting. I would note to you, you'll see the 2023 replacement resources is at the bottom section of that tabular display. You are looking at a 740 total megawatt addition, which becomes an effective load carrying capability of 279 megawatts. And when we start using those terms in that sense, with that effective load carrying capability and what loss of load planning really is, you really are very much swimming into the deep end of the pool. And it's quite complicated, but that's what's necessary to supply for both. The 740 is necessary both as replacement and then to ensure reliability. I'll just proceed on. The rule in this case, we heard a lot of argument about what, should the RFP involved Valencia bids? I mean, that was basically the entirety of the hearing, but we didn't hear a lot about the actual standards for 551. They're relatively straightforward. No electric utility shall become irrevocably obligated under a long-term purchase power agreement without first obtaining the Commission's written approval. The utility must demonstrate that the long-term PPA is needed, will provide net benefits to customers over the duration of the agreement. The rule goes on to provide, and you see this, I didn't highlight it, but in the bottom section here, a plethora of evidence that they're obligated to submit. I walk through that, copies of the PPAs and ESAs. The next question becomes the key terms that was submitted. I won't go through all that here, but it's all set out in there. The prices, the nameplate capacity. I will note in the course of the hearing, one of my questions, we've all heard comparisons of what constitutes a very valuable, or I could say economically efficient solar project or a wind project. Since this is a very early stages for PNM in terms of battery additions, I asked Mr. Falgren, what is a good cost of a battery project? And effectively his answer was, as you can see, I'm skipping a lot of this. I believe he said it was between $6 and $9, or 7 was sort of where you want to go. And that's here. So Mr. Falgren reported, if you see a battery price that's $6 a kilowatt a month, you should buy that every day. If you saw a 9, that's one you should question. So that's the range. And all of these battery projects effectively fall around 7. And I believe I was reviewing the San Juan replacement resources, and those were priced at about 9. So I guess that's declining in value too, or the prices of those are declining. But in any case, the evidence indicated that these battery deals were all good deals. The methodology and the criteria is one of the factors that they're required to submit evidence upon, and that was the bulk of this entire case. But rather than just go through the RD, it might just be simpler at this juncture to tell you the overarching concern by Onward and the interveners is not, so we had in this case an abandonment of a 114 megawatt plant. So naturally you have to have resources to fill that hole. That was one major aspect of these replacement resources that was going on in this case. But as I said earlier, when you're looking at replacing firm resources with intermittent resources, you need so much more just to ensure there's reliability. Mr. Schlag talks about this at great length, and that's the first individual. And I'm going to skip over a lot of the yellow here that I've highlighted and just come down to, what I think is probably, as far as I'm concerned, one of the more important charts that were submitted throughout the entire hearing. So what you're looking at here is effectively how a system functions in a winter period of time on a week period with battery, solar, wind, and all of the varying types of resources you could have. And effectively what you're seeing in all that colors is the way all of those resources are interacting with one another in order to meet load. And so at each one of these, there's a big peak of solar at the height at noon, right? And that's to be expected. But as it declines, it's not like more solar can solve the problem because, of course, the sun is setting. So what fills in what is referred to in this case as the net peak to serve net load, which is effectively load minus intermittent generation. And basically the E3 studies indicate universally you need some form of firm resource to come in. And you can see in this case, they have so much firm underlies everything: imports, hydro, biomass, nuclear. Then they have the renewables on top of that. But effectively, combustion turbines, combined cycle gas turbines, and I'm not entirely sure what ST stands for, but in any case, firm resources, traditional gas combustion resources are doing a lot of work in this particular model. Now, this isn't a New Mexico model necessarily, but E3's conclusion, having looked at lots of places, is this plays out everywhere all the time. And that question is what then set up this question about what was Onward really after here in this case. And my understanding of it is that their principal objection is that in the IRP docket, which is before this commission, 21-00033, that IRP from PNM says that Valencia project ends in 2028 when the PPA expires. And the question for the commission would be, well, is it going to be more efficient for PNM to procure smaller convertible gas units, or do you take your existing fleet, existing PPAs, and use them in some way? That's the case to come, and it's coming. And I don't think it's this case at all, frankly. That's basically my whole recommendation in this case is, yes, these resources are not opposed. There are meaningful questions underlying all of this, but we don't need to decide them now. And in fact, my recommendation in this case is to say, Onward's arguments belong in the rulemaking this commission set up to address IRPs and procurements. It is absolutely correct to address it there. Why? Because they're asking macro questions about PNM's generation portfolio. They're asking questions that should apply to every utility. They're asking questions that, frankly, they're abstract questions because this isn't a firm resource case. There is no gas unit proposed here. So what are we doing? And that was what Mr. Falgren said. I don't know why we're here. That's a perfectly legitimate question, but it's not that this case was a waste of time or the energy of the commission is poorly spent on this matter. These things will happen. And the question is, what is the best way to address them? And my recommendation to the commission is you do it in that rulemaking proceeding. And if you disagree, then it can happen in a subsequent procurement case, but not now. And I've said, I think all I need to say there, frankly, about the recommended decision and getting into it any further. I know the commission's only had 2 days maximum to even think about all what I've written. So I think I just want to conclude by saying, there is an additional aspect to this, and I'll stop sharing my screen at this point. I think there is an additional aspect to this case that, I did conclude in the course of reviewing this that NEE has an expert witness that I found not qualified to provide testimony on resource modeling, and did so for the reason that, as everyone in this case agreed, that's an enormously complex area to address. And frankly, that just the NEE had not satisfied its burden to establish that its expert was qualified. And I've made the recommendations that are within the RD. And so I will stop there.
Mr. Chair.
Yes, thank you, Mr. Ryan. Vice Chair Hall.
Well, I really appreciate this thorough explanation that hearing examiner Ryan has given us. But I do hear him saying, however, that regardless of all this complexity of modeling issues and so forth that he was walking us through, which I really appreciate, that this should not impede our decision that's before us today. Should not impede us from going forward on that with confidence. And I would like to move I'd like to make a motion to approve the order in front of us. But I also wanted to express my appreciation to what hearing examiner Ryan has walked us through, and my interest in seeing this issue fully developed in the rulemaking, in the IRP rulemaking case. Because I agree, it sounds like that's where it should be handled. So I just wanted to make that clear. Thank you.
Okay, so we have a motion on the floor to approve the order. Do I hear a second? Okay, we have a second by Commissioner Fishman.
Mr. Chairman, Commissioners.
Pardon me?
Mr. Chairman, Commissioner Michael Smith.
Yes.
I just wanted to clarify in response to Commissioner Hall's motion that the order that's proposed for the commission at this time relates only to the replacement resources. It does not actually address the issues relating to the RFP process, which hearing examiner Ryan did discuss. But the order that went out yesterday basically provided that, and that was the order that the parties responded to, is that they stated they did not oppose the issuance of an order, a separate order, in this case, addressing the replacement resources so that could move forward. A number of parties did indicate that they intend to file exceptions as to the conclusions and recommendations in the recommended decision relating to the RFP process and other issues that were raised. And the order provided that those exceptions would proceed under the normal schedule for exceptions. So obviously those have not been filed yet. So this order relates only to the replacement resources.
Correct.
Thanks for that clarification.
Great. I just wanted to make sure the commissioners were clear on that.
And Commissioner Fishman, you're clear on that, correct?
Oh, absolutely.
Okay.
Mr. Chair, I made my motion with that clarification based on the information that Mike provided in his clarification. I'm sorry, I didn't express it as thoroughly as Mike did. Thank you.
All right, any other discussion? We have a motion and a second on the floor.
Mr.
Commissioner
Chair,
Fishman.
I have a quick question for hearing examiner Ryan. At one point there, I was seeing news accounts of RFPs being issued by PNM and that they needed a lot more capacity than they originally thought, and therefore they'd done an RFP of an additional 700 megawatts. I can't remember what it was. And under our current rules, they're not required to let the commission know about these things. So my question is, was that RFP related to this case? Is that what these, or is that a separate deal, or don't you know?
Yeah, and so I believe I understand what you're saying, Commissioner Fishman, and I think so. In my case, the RFP that was issued was referred to as the 2020 RFP, and that RFP was issued shortly after PNM made the conclusion, having done the analysis, that PVNGS was just no longer the most cost-effective deal. They concluded, well, let's go out and hunt for resources. And they did that in the exact dates I don't have off the top of my head, but that was the 2020 RFP. There was varying references to a subsequent RFP that has been issued, which I have not seen and was not the subject of my case. And I assume that that was the document or the RFP to which you are referring now.
Okay.
And I believe, the point is that Onward made in this case, and, we'll hear more about this, obviously, based on the order, is this is not a process by which time just stops, right? Everything keeps moving forward and RFPs get issued. So it's challenging because you have to address this stuff. And I give Onward, credit for saying that we need a resolution of this, but I don't know that this is the case to do it.
Yeah. Okay. Thank you.
You're welcome, sir.
Any other discussion on the motion? I think this case really illustrates the crux of what we're dealing with in this transition to clean energy. But specifically with respect to this case, the way I see it is PNM gave notice on June 11, 2020, that it would not repurchase the leases and would allow them to expire, but really didn't commence the matter almost a year later on April 1st of 2021. And I think hearing examiner Ryan illustrated to us very clearly that we have to remember that we're bound by constitutional procedural due process. It requires the convening of affected and concerned parties and interveners, and they have the opportunity to be heard and participate in these proceedings. And, we're dealing with some complex matters, folks, that requires modeling and testimony to be fully understood and adjudicated. And obviously, we have recently, as hearing examiner Ryan noted, we're just coming off the heels of hearing some major cases that were very close in time in terms of requiring a decision per our procedures. So the bottom line is we need to get these applications earlier to account for the time necessary to go through our own procedure and policies. And I think we're doing our due diligence by taking every opportunity to accelerate the approval of these needed replacement resources, as was stated in the 3137 filing by PNM. They indicated a reserve margin of negative 3.46% or 3.45%, and it excluded these replacement resources. And I don't think these replacement resources will be online, certainly by this summer, but they could very well help avert any potential reserve margin issues in summer of 2023. Anyway, that's just the way I see this case. Commissioner Fishman.
Thank you. And one final comment is this just refers to the rulemaking currently underway, IRP procurement. This is exactly the problem that this rulemaking is trying to address, that we have a process that's well known that leads to timely submission of these kinds of resource requests and allows for thorough vetting and allows for a situation where we don't find ourselves suddenly scrambling for resources because of late submissions. I will say that utilities in their comments so far in this case keep insisting, well, what problem are you trying to solve? Why are you doing this? Why are we doing this rulemaking? Well, this is exactly why we're doing this rulemaking. And I just want to make that as clear as I possibly can. So, thank you.
Thank you, Commissioner Fishman. Any further discussion? We have a motion and a second on the floor. Any further discussion? All right, Russell, please take the roll call vote.
Commissioner Vicente Aguilar,
Aye.
Commissioner Byrd,
Aye.
Commissioner Hall,
Aye.
Commissioner Maestas,
Aye.
and Commissioner Fishman.
Aye.
The proposed order is adopted unanimously 5-0.
Great. Thank you, Christopher Ryan and Michael Smith. Let's move on to item 10 under discussion items. This is a discussion regarding opportunity to join the Western Public Utility Commissioner MOU on climate cooperation. And our very own Vice Chair Hall will lead us in this discussion. Vice Chair Hall.
Thank you, Mr. Chair. So I don't know if you guys received in your email this morning the 3 documents that I wanted to speak from. So I need to ask Isaac if he could put them up one at a time on the screen, on the shared screen. Isaac, can you select the one that's entitled Western Public Utility Commissioners Joint Action Framework on Climate Change and put that up on the screen?
Mr. Chair.
Oh, Sarah,
Commissioner-
Sarah.
Yes, I actually don't have those. If somebody could send them to me.
Is Isaac in the meeting? He's usually in the meeting.
I know he was getting the record copper ready today. Oh,
There he
Thank
is.
you.
He started screen sharing. Okay, and if you'll scroll down to the bottom so the parties can see, so the commissioners can see their signatures of 6 Western PUC chairs. And this was put together in 2020, and their states are California, Washington, Colorado, Oregon, Nevada, and Hawaii. You can scroll up to the top now, Isaac. Oh, I see. I see a text that says his microphone may not be working, but he's on his computer as usual. That's great. Oh, I am not on my usual computer. I see. Well, thank you for
If you
helping.
can expand that view.
I beg your pardon?
Just asking Isaac, just if he can zoom in on that a bit.
Oh, yeah. What this is an MOU among the commissions listed right under the heading. And notwithstanding the fact that in paragraphs further down, they only list 3 of them because initially this organization was made up of 3 commissioners, 3 commissions. What New Mexico has in common with these 6 other states is our aggressive RPS requirement that we get to 80% clean energy, renewable energy by 2040 and 100% of clean energy by 2045. These other states have similar requirements. And they've decided to join together because they, like our state, is interested, the utilities in their state were interested in seeing the development of a regional wholesale trading organization of some sort in the West. And there are numerous plans, numerous groups that have combined in the West to try to design such a market. And these 6 state commissions have concluded that unable to protect their interest in moving rapidly toward their clean energy goals in their states, that they need to find a way to participate meaningfully in these several different forums where developments of a regional transmission or organization or wholesale trading organization are being designed. And the reason is that ordinarily when a wholesale trading organization, a regional trading organization operates, they operate on a resource neutral basis. And yet those 6 states and our state do not have resource neutral objectives. So we need to be able to participate in a way in these developments, these different varying developments of plans for a trading organization. We need to be able to participate in them in a way that will ensure protection of our utilities' participation in these markets in a way that will help facilitate them being able to acquire sufficient renewable energy sources from trading in those markets. Otherwise, they could be compromised if they want to join such a market in being able to acquire sufficient renewable energy through the market. So this is an effort to look ahead, get involved in the ground floor of design of how these markets or proposed markets, different designs would operate to make sure that there is no compromise to the states whose needs are directed by their aggressive targets for renewable energy. So what's in it for us? And you can scroll down a little bit. You might scroll down through the language. Let's see. Let's start at the top. Let's hear. This is a good place. Shared principles. Regional cooperation to address climate change. Development and use of low carbon technologies in the energy industry. Promotion of cost-effective conservation and demand response. A strong continued commitment to renewable energy resources, support for energy planning processes that recognize the ability of low carbon resources to provide reliability and cost-effective benefits while fostering new technology and innovation, and advancement of infrastructure to reduce carbon emissions in the transportation industry. I don't know if all of us on the commission embrace all of those values. I know I do. I'm sure there's a little disparity there, but I think what's more important to look at is action items. If you'll scroll a little bit more, Isaac, so we can look at those. What the action items in their shared in this agreement are the following: review the best practices and pursue joint opportunities to identify and secure cost-effective conservation. Review best practices for demand response and develop joint activities to increase beneficial demand response capability. Examine opportunities to further support and implement renewable energy development to service the Pacific Coast states has now been broadened, and they haven't revised the language, but it's now those 6 states, not all of which are Pacific Coast states, including policies to encourage the development of cost-effective transmission that provides access to prime low-cost resource sites. Seek opportunities to share analysis of the benefits, costs, and reliability of variable generating resources, cost, benefit, and reliability information in areas of increasingly variable generation resources. Explore the collaborative development and use of low carbon energy capacity resources, low customers' costs, and improve system reliability. Explore the costs and benefits of regional transmission markets to better utilize resources and protect ratepayers. Share best practices in grid modernization, including distribution planning and operations, distributed resources, and distribution and transmission interface. Work to ensure regional energy markets maximize benefits to ratepayers in, it's no longer just Pacific Coast states, it's members of this MOU. So I think you can see from this that there are many common interests, certainly best practices in grid modernization, cost benefit, exploring the costs and benefits of regional transmission markets. There are many benefits that I think can come from working together with these other states who have these objectives. Now, Isaac, I'd like to ask you to put up, What are the other documents? The one starting representing progressive Western states' interest in regional market processes. So they state their proposition now in this document, which is more recently created. So it includes Oregon, Colorado, Washington, and Nevada. They left out Hawaii because Hawaii is not involved in this particular part of it. Well, and this paper is discussing the ones that are on the continent, the states that are on the continent. And they state that these states should explore banding together and partnering with a regional nonprofit organization to staff up and more effectively represent the collective interests in the ongoing regional market processes. It says the sheer volume of activity in the West, coupled with the limitations on existing efforts to protect progressive states' interests, likely requires new approaches and thinking, as well as far greater resources and support. And you know, this was written with the word progressive, and I don't think we need to characterize our state as being progressive. I think they use that term to refer to the nature of the environmental goals of the state, meaning progressive insofar as it will move progressively, rapidly toward clean energy adoption. So if you can scroll a little bit more, Isaac, if you scroll up so we can see more of the subsequent, okay, that's great. In this paragraph entitled "The Concern," can you scroll down just a little bit, Isaac, so we can see the beginning paragraphs of the paragraph titled "The Concern," which is upward from where you are. Okay, there we go. Over the past, no, you're fine. You're going too far. Just start where it says "the concern." So this is where this sort of explains what I did state. Over the past 2 years, multiple new opportunities have arisen seeking to enhance regional coordination in the West. These efforts include the CAISO day-ahead market, which we've discussed at the commission, the SPP Market Plus option, which I think they came and presented to us. That's the SPP Market Plus option is SPP's offering in the West of something which would be also a day-ahead market. It's not, it's still in very beginning development stages. The Western Resource Adequacy Program, that's a combination of states, utilities, trying to establish a sharing agreement. The Western Regional Exploratory Group, that's a similar thing. And the FERC ANOPR process we participated in last summer. FERC had issued an ANOPR, Advanced Notice of Proposed Rulemaking. The advanced portion meant they were seeking information from essentially, in that case, all states on what they should put into a NOPR, because they were trying to provide an opportunity for us to explain our needs as we see them, various states, on how to address climate change impacts going forward. So FERC is working on that, but we participated in that. And it had bearing on states' interests, among other things, in developing more stringent clean energy rules. Anyhow, this goes on to express the philosophies as decisions made in each of these forums and within numerous subject-specific sub-processes could have significant economic and environmental impacts for Western states. State regulators in the West have relied on their own efforts in these various organizations. The Western Interconnect Energy Board and the CREPSI, which is let me see, Council on Renewable Energy. I can't remember the whole acronym, but it pertains to Renewable Energy Coordination in the West, to staff up and effectively represent the collective public interest in these processes. While this approach has been very useful with real benefits, it also has its limits as it is a consensus-based process that often defaults to the lowest common denominator. You know, I don't need to read all of this to you, but essentially what this is saying is they want to have this small number of states who have statutes in place that establish the aggressive clean energy standards to operate together to be able to pursue those interests in the development of designs for day-ahead markets and eventually trading organization in the West. Because while they have been working through these larger organizations that are West-wide and include interests of all the states, they all have to agree. And the fact is there is not agreement. Actually, the next paragraph, starting with part of limitations, does address that. Really, it's the next paragraph. Issues of regulatory philosophy also limit the ability of WEEB and CREPC to exercise meaningful leadership in the West. Some Western regulators, as a matter of philosophy, believe utilities must drive discussions forward and that the most appropriate role for the regulator is after the fact cost review. This approach effectively cedes leadership to the utilities and can limit effective advocacy in regional forums. That's actually not the issue I've meant, but that is also, I think, something where we differ. Okay, no, it's the paragraph above. Part of the limitations arise, scroll down, there you go. Part of the limitations arise from the real environmental and clean energy policy differences among states. For example, certain states such as Oregon, Colorado, Washington, Nevada, and Arizona, and New Mexico have committed to decarbonize their energy systems in an economically sustainable way, while others have not. Other differences may exist between California, which is doing its own thing, and these 4 Western states that operate under more binding economic constraints. So what they're trying to say is we need to band together with the states that have the same interests we have and the same economic capability to try to participate in the development of whatever we end up with as a day-ahead market, first of all, which would allow the utilities participating in it, including our state utilities who would be there, and that would be PNM and El Paso Electric, allow them to realize substantial savings in the capacity they acquire and provide to our consumers. So if you'll scroll down further now, Isaac, appreciate it. A little bit farther, towards a new approach. This paper suggests that state regulators in these states come together and partner with a regional nonprofit to effectively represent our collective interests in these regional markets processes. The goal would be to quickly staff up with real expertise to comprehensively prioritize the pending opportunities and begin exercising leadership to take advantage of the benefits of enhanced coordination in the West. And what they have done is, first of all, they've acquired funding from a nonprofit so that none of the states have to pony up any money, and they've engaged the services of RAP, a Regulatory Assistance Project, to participate so far in the process at CAISO wherein to develop the design of their day-ahead market that is part of the Western Energy Imbalance Market. The Western Energy Imbalance Market is developing under the auspices of CAISO a day-ahead market, which means bids can be made a day ahead, and it permits the participants to be able to make much more advanced planning than they do under the present operation of that market now, which was it's like a 5-minute trading market. If utilities find themselves short or long in electricity close to the end of the day, they can participate in the Western Energy Imbalance Market at that time to essentially get whatever they need. If they need more electricity, they can use that market to try to acquire it. But in a day-ahead market, when the utility has more time to make plans, they can even realize more savings through their trading. So, one of the numerous workshop processes that are going on in the design of the day-ahead market to evolve from the Western Energy Imbalance Market involves greenhouse gas accounting. And these states and we have statutory greenhouse gas accounting requirements. So, so far, these states have a person who is a member of the RAP organization, participating in those workshops and reporting on a weekly basis to this group of MOU commissioners. And they are also trying to, represent these states' interests in the development of the greenhouse gas accounting methodology so that it will be supportive of these states and our state. Well, they're not representing us yet, but it would be supportive of their interests in making sure they comply with their greenhouse gas accounting metrics in their own respective states. So whatever will develop in terms of greenhouse gas accounting in the day-ahead market would permit the most ease in conforming accounting of states with the conforming of accounting in the market. That would be a service that would be good for our state. And I know there have been more detailed bills introduced. I have no idea whether any of them passed this session that require more detailed greenhouse gas accounting requirements than we have right now. So that would be one, that would be the first example of how we could benefit from being a member of this MOU. And it costs us nothing out of our pockets. And it provides us an opportunity to have a representative on our behalf participating in workshops such as the greenhouse gas accounting one going forward as plans are laid down for more advanced trading markets in the West. So I see pluses for our state and especially for our state's utilities who need some clarity in the rules that are formed in trading markets, and they need provisions in the design of the market, whatever we come up with, whatever is the eventual market, that will help them more easily conform to their state law. So that's the purpose of this MOU. And I would like to ask the commission to agree with me that this is a good thing to join. I see great benefits coming from it for our state. And I welcome any questions about it.
Thank you, Vice Chair Hall. Any questions regarding this?
So, Mr. Chair?
Commissioner Fishman.
I'll just add a couple of thoughts. Is that in talking to commissioners from these other states, Oregon, Colorado, Arizona, one of the issues that seems to come up is they all want to partner and get something done where there's more coordination and perhaps the regional markets. But there's this fear that the efforts will be that if we don't do this, that folks will be faced with two choices. One, join with CAISO in their markets, or two, join with SPS in their markets. And there's a real, not SP, I'm sorry, it's not SPS, but
SPP.
Pardon?
SPP.
SPP, thank you, Cynthia.
Right.
And that they'll be forced to adopt a lot of things that really are suited to those specific markets, but aren't suited to these states. And that the needs of these states will be trampled, quite frankly. And folks see this particular approach and this particular collaboration as an opportunity to be sure that doesn't happen. And there are some real differences about the needs regionally. And I do think personally that New Mexico, by joining this, puts itself in a position where it has more options. And instead of jumping into something that was designed by someone else, but not for us, it allows us to create a design that really serves our needs. So I know we've got a lot of resource issues. Do we really have resources to devote to this? My experience is if when you get in these coalitions, if you have fewer resources, at least you're able to kind of keep track of what's going on and what the discussions are. And that in itself is a huge benefit. So my take is it'd be a good idea to join into this coalition, if you will.
Thank you.
Thank you, Commissioner Fishman. Vice Chair Hall.
Well, I was just going to thank him as well for his comments. You did receive a third document, but I decided it's pretty self-evident on its face, and I want to avoid, commissioner fatigue and excess time consumption by reading through it. But it's a document that's entitled, well, it's got 3 bullets on it, 3 paragraphs. It describes overview of what the objective is, and it mentions a budget, but that budget is no longer relevant because RAP is being paid for by a funder. And then the last paragraph is entitled Decision-Making, Communication, and Other Issues. For those of you who want to understand more of the details of the structure. But I agree with Commissioner Fishman. This provides us a voice at the table, and we're creating our own better options. So if there are any other questions from any of the commissioners, I welcome them. Otherwise, I'd like to ask Mr. Chair if there could be a vote to support joining this group of 6 other states.
Well, the way I see the agenda is we didn't indicate that there'd
we
be
didn't.
potential action. Yeah, we just indicated
Correct.
as a discussion item, but I support your recommendation. And I hope that they're willing to include us because they made it a point to mention Pacific states, and we are definitely not a Pacific state.
Right.
But if they're willing to include us, I think this is a great idea. And let me just ask either Michael Smith. So if we made a decision to be a part of this group, what What would that require, a resolution or simply an action item to vote on requesting inclusion? What would be our official action, and can we take it as soon as next week?
Well, a resolution obviously would be incorporate a vote. I mean, I think you could do it either way, but a resolution would provide a tangible document that the public could, review and see what the basis for the commission's decision to take that action would be. So I think that would be an appropriate way to do it.
Okay, then let's plan to consider a resolution at next week's meeting, which would recommend inclusion into this organization.
Great. Thank you. Thank you very much, Mr. Chair. We'll put that on the agenda, and I appreciate it very much. Thank you.
Okay, thank you, Vice Chair Hall, and thank you for your leadership in bringing these regional issues to bear. I mean, I think it's got applicability to a lot of what we're talking about and experiencing. So thank you for your leadership.
Thank you.
All right, let's move on to discussion and potential action regarding legislative matters. Wayne, you didn't list any specific bills, just, I guess, past bills that we've discussed. Do you have any insights, highlights, lowlights to share with us?
Well, Mr. Chairman and members of the commission, good morning. Nice to see everybody. According to my watch, there is 24 hours and 3 minutes left in the 2022 legislative session. So it is wrapping up. The only bill that we've been tracking consistently that it still seems to have some life to it, actually has life to it, is Senate Bill 198. That is the bill that would transfer the Transportation Division from the PRC to the Department of Transportation. That bill, I believe, is actually being heard right now in House Government Elections and Indian Affairs Committee. Been trying to check and see if that is still ongoing, and I believe that committee hearing is ongoing. And Senate Bill 198 was second on the agenda for the committee this morning. So as soon as we wrap up here, I'll jump off and see if that what has happened with Senate Bill 198 and update the commission on that. House Bill 2, the General Appropriations Act, the House declined to concur with Senate amendments yesterday. So that's in conference committee. We don't expect that will impact any of the items related to the PRC that's in House Bill 2, but we, of course, will be tracking that all the way to the end as well. The only bill that's not on this list and hasn't been on this list, wanted to mention, is a Senate bill, I believe it's 202. It increases the salaries for certain elected officials. The impact to the PRC is that it would also increase salaries for incoming commissioners on January 1st of 2023. So again, we haven't really been involved with that legislation, but it is that does have some impact going forward on the agency. And with that, Mr. Chairman, I'll happy to try to answer any questions about the bills we've been tracking. And of course, we'll continue to keep you updated as the session winds down over the next 24 hours.
Thank you, Wayne. I guess I just had one on SB 198. I realized that we didn't have any kind of a consensus whether to oppose or to support that legislation. So per our policy, we're free as individual commissioners to express our own personal position on this. But Wayne, what message did you convey to key legislators that are going to be taking this up, particularly in the House?
Mr. Chair, I don't believe I've had any conversations with members of the House, and the only communications from me were during the committee hearings in the Senate, which is the position of the commission on the legislation is neutral. Some commissioners, as you noted, supported the concept of the transfer. Some opposed it. So our official position is that the commission has been neutral and that we are available, staff is available only to answer technical questions related to the legislation.
Okay, thank you, Wayne. Any other questions for Wayne regarding legislation or anything else in his wheelhouse? Any questions for Wayne? Yes, Commissioner Fishman.
Just a quick thank you, Wayne, for all the work on budget issues that you've done. The future looks a little brighter than it did a year ago, and I think you're a big part of that. So thank you, thank you, thank you.
Thank you, Commissioner.
Mr. Chair,
Vice Chair Hall.
well, I just feel I need to modify what Commissioner Fishman just said. I think they look a lot brighter. I think things look a lot brighter than they did a year ago. I think Wayne's made a tremendous difference in our ability to find financing to do some things we need to do, including hire more staff. So I'm very grateful for the changes that his presence on the commission, has brought.
Commissioner Hall, never correct me like that again.
Well, excuse me. It was an amendment. It wasn't a correction.
Okay,
It was an
I'll call it
addition.
friendly.
All right, you two behave yourselves. All right, any other questions for Wayne?
Well, I have a comment, Mr.
Yes,
Chair.
Commissioner Byrd.
Just to keep everything in check, somebody has to push back a little bit. The budget probably wouldn't have been approved the way it was if it wasn't going to be partially shared by their appointed people. So I just don't want Chief of Staff props to get too excited there.
Thank you for keeping me humble, Commissioner. I appreciate
There
it.
we go.
I do
Fair
my
point.
best.
Yeah.
So, Mr. Chair,
Commissioner Fishman.
I saw Wayne's big head just shrinking as Jeff talked. So can we call him the head shrinker from now on?
Oh, you can call him whatever you want.
Okay, well, thank you, Jeff.
Just don't call me late for lunch.
Yeah.
Y'all are getting jiggy. Okay.
Yeah.
Anything else for Wayne? Okay, let's move on to communications with General Counsel. Michael Smith.
Mr. Chairman, I will defer to Russell if he has anything else. He's been more involved in the matters that took place while I was gone, which I think are continuing in the commission's various things before them.
Mr. Chairman, I have nothing.
Yes, Russell. Okay. Okay, but are there any questions for General Counsel from any commissioners?
Mr. Chair,
Commissioner Byrd.
no questions. Just good to hear Mr. Smith. And thank you for the work you're able to do and focus on your priorities. Thank you, Mr. Chair.
Thank you, Commissioner Byrd. Anything else? Any comments or questions for Officer General Counsel? All right, let's move on then to communications with commissioners. Come on, I know you're all, I think it's champing, not chomping, but champing at the bit. Come on now, I know you're not shy. Any matters from commissioners? Oh my goodness.
Well, Mr. Chair, I was wondering if anybody attended the NARAC meetings. I didn't. I was going to try to do it online, but I had no time. I see Commissioner Byrd smiling. Did you attend any, Commissioner Byrd? Just curious.
Well, I guess then I will kick this off. As your chair, I'm really proud of this agency. Obviously, I've only been on this commission for a little over a year, and what I have seen is a group of professionals dedicated to their craft and dedicated to following the letter of the law. And so I'm proud of the work that we're doing, and we're facing enormous challenges. And as many folks out there know, we can't really do this alone. The way, for example, our cases unfold is that we have applicants, we have key stakeholders that are formal interveners that actually contribute to the final outcome of these cases and help develop the evidentiary record. And I think we saw in very stark and clear terms from one of our hearing examiners, and I'd bet good money that he represents the sentiments of our other hearing examiners, that we're adhering to our own timelines. We can only react to what is requested of us through formal actions and filings here at this agency. And, this notion about all of a sudden, we could be facing blackouts or brownouts in PNM service area, I think is certainly an oversimplification of what we're facing. I don't think that really reflects the facts regarding pertinent cases, that particular cases that relate to replacement power for the San Juan Generating Station. And so I think it's incumbent upon this agency to respond. And one thing that we're doing is we're in the final stages of developing an op-ed piece to respond to some of these related articles and opinion pieces that have been published in major newspapers in the state. Also, as many of you know, we've been working on the issue of addressing summer readiness and supply chain issues through formal dockets for months now. And we have some information that is significant and certainly needs to be shared, but we need just a bit more of information. And so we're working on a more detailed list of questions to ask in those dockets regarding summer readiness and supply chain issues. And I think we're transitioning from assessing this situation to soliciting real concrete plans to address this challenge, particularly meeting the summer peak this summer. And so we have been working on this for months. I feel very comfortable in terms of the process and the proactive nature that we've had in this. But I think all the interveners and the stakeholders in the industry realize there's only one sandbox here, and we're all in this together. And utility regulation is I've come to realize it's very specialized, and it's a field that is very important to New Mexicans. And so this agency, I believe, has been proactive and judicious and adhering to our rules and our procedures. And I can comfortably say that this agency will do everything in its power to avoid any kind of scheduled interruptions this summer or next summer. And it's incumbent upon these utilities that are working with us on these challenges to let us know what their plan is, and if there's any formal applications where we need to begin our process of adjudication, then we need to know that. We need to know what these formal actions are. And I'm going to put it out there. The Attorney General did issue a letter. He's concerned regarding our decisions, and really what I would like to do is reach out to the Attorney General and begin face-to-face discussions on how we can work together to avoid any extreme measures like scheduled interruptions of service or blackouts and brownouts. We did that in the case of the propane issue. Based on all the complaints we were receiving, we were working with regulation and licensing on the propane issue because they have some limited regulatory oversight over propane suppliers. And To the Attorney General's credit, he agreed to investigate one particular supplier. And we know that that has led to legislation to provide greater flexibility in these propane contracts where customers, if they don't receive their propane deliveries from their own contractor, that they can seek supplies from a different vendor or provider. And so here's a clear case where we collaborated, it was informal, action was taken that led to real legislation to avoid future interruptions of propane deliveries, especially to our elderly and those folks out there that rely on medical devices that require continuous power. And quite frankly, you know, in this letter, I found many areas of common ground between the Attorney General's concerns and what we're doing. For example, we've been talking about how supply chain issues have curtailed the delivery or the acquisition and delivery of transformers. So this isn't just a matter of the delay of renewable energy projects to replace power from coal plants that are scheduled to be closed. This is an emergency preparedness emergency response issue. And so I think there's another area of common ground where we can work with the Attorney General to address these issues. And so I personally want to publicly invite the Attorney General to work with us. But I think perhaps a sit-down meeting would be in order. We are going to issue a formal response to the Attorney General's letter. We will issue a press release and we will also file the response to that letter. So I just, you know, as chair of this agency, I'm proud to be your chair. And particularly the staff, our hearing examiners are, as you've already heard, they're under a tremendous amount of pressure to meet our deadlines and our procedural requirements. And I don't think there's any kind of nefarious or intent to delay any of these proceedings. We address them objectively and impartially and do our best to expedite where possible. So I just wanted to make those preliminary remarks and just want to reiterate as chairman of this commission, I want to work hand in hand with the Attorney General and anybody else, whether it's Homeland Security. I think that's going to be another potential partner to work on emergency preparedness. I go back to what I said at the outset of my remarks, is that we're all in this together and we need to solve problems. I'm an engineer. That's what I do. I weed out all the noise and focus on the problem at hand. And certainly the Attorney General, he is the chief consumer advocate. His office has been involved in every single case, and that is part of the way we do business. And so there's really no need to create an alternate process or seek out other stakeholders that have not been involved in these replacement resource issues, in supply chain issues. Anyway, I just want to make it clear that I am reaching, my hand out to the Attorney General and asking that we work together cooperatively going forward. So with that, I'll just open it up to any other commissioners if they have any comments on the letter from the Attorney General.
Mr. Chair.
Mr. Chairman.
Vice Chair Hall and then Commissioner Vicente Aguilar.
So, Mr. Chairman, I'm glad you brought this up. I do think it's something we should discuss, and I share your views. As I was reading the letter, I had, a number of thoughts. First of all, thank goodness, I'm so glad the Attorney General is taking a big interest in things going on here. But the other thing I noticed as I read it was that, he was identifying issues that are definitely associated with the types of problems that can arise if there are blackouts or brownouts that are beyond our scope of jurisdiction, such as emergency preparedness and things like that, which may fall within his jurisdiction. But in any case, he certainly is well positioned to, he is identified as the office to protect residential consumer interests in our cases. So I completely share your desire to reach a hand out and engage him in working together with us. I think it would be very beneficial for the people of New Mexico. Another thing that this draws to mind is the idea that in many states, there's either a separate office for consumer advocates, or the Consumer Advocate Office is part of the Attorney General's office. And I know I believe they have dedicated attorneys. I know they have one or two who come and practice before us. But, to the extent the AG finds that with the energy transition and many issues that arise, noteworthy among them right now is whether or not there are adequate resources in our state utility plans and in the West in general. I think having his office's involvement increases our ability to perform our job insofar as their attorneys can do very significant work in developing our records, developing the record in cases, and then from a policy perspective, whatever his perspectives are would be very interesting to incorporate. So I think it's a good thing, and I'll stop there.
And I get Commissioner Vicente Aguilar.
Thank you, Mr. Chairman. Are we directing General Counsel's office to initiate a response letter?
Yes.
Is that how we're going to handle it?
It's just one of the things that we're going to do.
Okay, and I would like that draft letter to be circulated with amongst all the commissioners so that we all have input. Thank you, Mr. Chair.
Thank you, Commissioner. And I guess, in my remarks, I do have a message for the Public Service Company of New Mexico, and it's really more of a question than a comment. In the California Energy Markets February 11th edition, there was an article there where the CEO of PNM Resources, Pat Vincent Calan, who's chairman of the PNM Resources, spoke to industry analysts on February the 3rd. And this is a quote, and this is regarding adequacy of resources to meet summer peak. And her comment, and this is a quote, but I can assure you we do have the resources covered for the summertime. So I'm trying to reconcile this position to these industry analysts relative to, for example, the 3137 filing that's PNM's load and resource table that indicates a negative 3.46% summer margin. And I guess if I would, Judy, is there, how should we interpret this?
Hello, Commissioner Maestas. Are you asking how should we interpret the statement made in the article by the CEO of PNM?
Yes, I mean, shouldn't there be a consistency there in terms of the filings we receive and statements like this, where or the CEO has made assurances that they have enough resources to cover the summertime peak?
Yes, it appears to not be totally consistent with the pleadings that have been filed in several different dockets here at the commission. And I think we need to request clarification to reconcile these different statements.
So is this something we can do in an appropriate docket? Or
Yes, we have a docket regarding compliance with the San Juan abandonment that we have been issuing bench requests in. I think that would be the appropriate docket to issue some issue follow-up questions. And we've had responses filed in that docket. In particular, we had a response filed by the AG and NMPRC making very good suggestions. And I think we should include their suggestions into our follow-up questions.
Thank you,
Mr. Chair.
Judy. Hold on, Vice Chair Hall. I just wanted to state for the record and let everyone know that, we have established an internal group within the agency to determine a strategy to address some of the information that we've received thus far regarding the supply chain issues and summer readiness. And so we'll be meeting tomorrow morning to go over the draft inquiry. And my hope is that we will include a question regarding this statement of assurance by the CEO of PNM. So I just wanted to let folks know that we're meeting weekly and we're on it, and we're taking decisive action. So with that, Vice Chair Hall.
Well, Mr. Chair, I was only going to comment on Judy's remark about filing the comment or issuing questions from the San Juan generating case. I would also like to have it issue a bench request or something from the combined docket that we have on resource adequacy and supply chain issues. We combine that into, I think, just one docket, 159. And I would like to, I thought we were making plans to issue a request to provide some clarification from that docket as well. So
yes, we are, and we can decide where to best place questions. That being said, we should probably postpone talking about either one of these dockets, since that is not on the agenda.
Correct.
And that being said, we are working on developing follow-up inquiries.
Mm-hmm. Yeah. That satisfies my query. Thank you, Mr. Chair.
Okay, any other matters from commissioners? Yes,
Mr.
Commissioner
Chair.
Fishman.
Chairman.
If you don't mind, Commissioner Aguilar, I'll just go real quickly and be done in a second. With PNM, I guess the question for me, when we're talking about resource adequacy for the summer, is for summer 22 at least, I'm not even sure, based on their communications, inconsistent communications, that we have a resource adequacy problem. And just to follow up on what you mentioned, Mr. Chair, at the end of January, we got reports in a loads and resources table that said we're 3% short with no reserve margin. On February 3rd, their chairman person is talking to shareholders and analysts and telling them she's got an 11 by 17 sheet of paper, and they have all kinds of options for summer 2022. And they will not face a resource shortage. And then a week later, they're feeding information to the press, and the press is printing reports of potential rolling blackouts during the summer. And so I have a question for PNM. What is the story? It seems like there's different messages going to different people. And I have to be very honest, it creates a real trust issue for me. The second thing I want to point out is that we're looking at the AG's cooperation with the agency. And in the AG's letter, I can't help but note that there seems to be a sense of, oh, the commission's doing something wrong and the commission is to blame. And, everyone can have an opinion, but I want to point out that at least in terms of cooperating with the AG's office, that to solve these kinds of problems in terms of resource adequacy and late decision-making that creates resource adequacy problems, is that one of the very helpful participants in our procurement and IRP docket, which is after all meant to solve those problems, is the AG's office. And in fact, they've been very supportive, AG staff, of the effort, and they've made some terrific suggestions. And the staff at the AG's office seems to have a strong understanding of the conundrum that we face if we don't get some rules in place that guide procurement, so that we don't run into these kinds of problems going forward. And so what I just like to say is, unbeknownst to some folks, many in the AG's, or several folks in the AG's office, are already collaborating with the commission to address these issues. And very supportive, and just as far as I'm concerned, terrific and helpful participants in that process. So I just wanted to make those 2 points, and I'll hand it back to you.
Thank you, Commissioner Fishman. Commissioner Vicente Aguilar.
Thank you, Mr. Chairman. 2 things I would like to mention. When you talk about the California Energy Markets newsletter, that can, anyone, any citizen can Google that. It's a newsletter, so it's public information, and I believe we are focusing on page 20 of that newsletter. The second thing I would like to say is that this is a trend. This is a trend of how Public Regulation Commission has been treated the past few years. We didn't get no consultation when we were given the eviction letter. And now we're in another phase where we have our weekly public meetings and the public comment is stated on the agenda. And my recollection is that we have not received any invitation or acknowledgement from our State Attorney General, Hector Balderas. He's certainly invited to come to our meetings and express his concern, and I will be open to that. Thank you, Mr. Chairman.
Thank you, Commissioner Vicente Aguilar. Any other matters from commissioners? Yes. Yes,
I would like to state that we recommend 2 commissioners be involved in a working group, not more than 2, because that would be potentially a quorum and an Open Meetings Act issue. So if two commissioners could work on a letter, then, and bring it back to the commission as a whole, that would be the appropriate way to handle this.
Okay, thank you for the suggestion, Judy. And let's set a goal to act on a response letter to the Attorney General's letter that he sent us. It was dated February 15th. And we'll also ensure that that letter is filed in the appropriate docket. All right, anything else? Any other matters from commissioners? Okay, hearing none, let's move on to discussion and potential action on the 2022 work plan. This has undergone a few iterations, but I wanted, the ideal work plan for me was to have milestone deadlines with folks identified in every single action item. And, you know, we don't quite have that, but I think for the purposes of moving forward and implementing this plan, I suggest that we just go ahead and take action on this work plan. I don't know what version you have. I guess Christopher Hall, my assistant, sent you the latest version that included some changes where, at least where we could identify folks that could lead those efforts. Office of General Counsel provided us with a more detailed window into the caseload for the remainder of this calendar year. So I think that was some additional detail that we needed. Are there any comments on this work plan? And I think Vice Chair Hall, I think you also put forth some suggested changes to it. Thank you for that. Commissioner Vicente Aguilar.
Yes, Mr. Chairman, I just want to give you an update as well as everybody that's attending this meeting. I held my first meeting, telephone conference with Michael Rippiker and Eugene Evans, and I wanted to get some background information in reference to the office of the new Office of Broadband. And what I understand from that meeting is that they do not have a chairperson yet. And I also understand that they introduced a bill so that the chairperson can be the director or director of the broadband office. So, so that is pending. And we really can't do any formal process at this point in time because everything is pending at the legislature. So we're looking at the staff, specifically Michael Rippiker and Eugene Evans. They're gonna contact me when they are ready to start communicating with the broadband office and all the new affiliates, such as the new council. So I just wanted to let you know that we had our first meeting and we're just gonna wait until I hear back from staff. Thank you.
Thank you, Commissioner Vicente Aguilar, and thank you for your leadership in the areas of broadband. As we all know, our state is in dire need of additional broadband expansion. So thank you for that. I'm just going to mention the key sections of this work plan. As I mentioned, General Counsel has listed the caseload for the remainder of the year. I'm happy to report that we have several rulemakings that are underway, and that includes transportation electrification. We're in the final stages of bringing forth a final rule on community solar. Commissioner Hall and Commissioner Fishman have been the catalysts to finalizing the interconnection and IRP rules. So we're making great progress. As you know, we've had a backlog of these rulemakings, and it's been problematic to implement a statute in the absence of a rule, as we have found out in the case of transportation electrification and rate decoupling. We also have a list of potential rulemakings that we think we can potentially get done. I'm not going to go through them in detail. Obviously, under resource adequacy, we have formalized that. It's a prominent element in this proposed work plan. And I think the other part of this work plan entails having our agency engage with sister agencies on important issues like transportation, electrification. We have some staff members that are engaged in a lot of the ad hoc climate action groups that's being led at the state level. So I really think it's incumbent upon us, given the infusion of millions, if not billions of federal funds into areas that are germane to our agency, like broadband. I think it's important for us to engage with the state entities and the new Connect New Mexico Council. And I think Commissioner Vicente Aguilar is already initiating discussions on that. So I think this agency can play a key role in working with all the appointed officials that are gonna oversee the allocation and expenditure of these federal funds. So I'm really pleased to see that here. One thing that I did add is I believe it's time for us to discuss formalizing a policy to institutionalize or mainstream alternative dispute resolution techniques to reduce cost and time impacts from protracted litigation. It's already a statutory mandate for us to exercise at opportune times alternative dispute resolution techniques to do just that, to mitigate protracted litigation. And there are some other operational issues listed there. We have circulated this work plan to all the divisions on the advocacy side. We've circulated it to commissioners. I think this is an effective roadmap for us to finish out the year with many accomplishments. So with that, are there any questions or comments on this draft work plan? I would like to approve it if we can. Again, these kinds of documents, they're working documents, but I think for our purposes of using our limited resources wisely, I think it's important that we move forward and adopt this work plan outline. Any comments or questions? If not, do I hear a motion to approve?
So moved.
Okay, we have a motion by Vice Chair Hall. Do I hear a second? Second by Commissioner Byrd. Any discussion on the motion? Just under discussion, I think, you know, Commissioner Fishman, when he was chairman, he started this tradition. I think it's vital. I really don't think it should be discretionary, especially for an agency like ours. So I want to thank Commissioner Fishman for requiring this of us a year ago. So any other discussion? We have a motion and a second on the floor.
Mr. Chair, I just want to ask a clarifying question.
Sure, Vice Chair Hall.
Oh, wait, I think I found the answer. I was going to say, I believe that, you know, the MNERD, Energy, Minerals, Natural Resource Department is very important for us to coordinate with, but I see that we have a bullet about that. So that may cover it. Certainly, they have a strong interest in 3 of our rulemakings, I would say, at least. Community solar interconnection, grid modernization. And I have spoken with the secretary once, but I haven't heard back, and I'm going to reach out to her again because it would be very nice to have their involvement in any way, you know, in those rulemakings. And but I see we have a bullet here that addresses that, initiate statewide coordination. Well, that pertains to transportation electrification. Of course, that's another issue that they're involved in. I think they're a very important agency for us to partner with, bottom line. So I think we've got that covered in this, and so I have nothing further to say on it.
Thank you, Vice Chair Hall. I just wanted to illustrate one example where I think we can have an immediate impact. I think we've all heard about some of the federal funds that have been made available through the infrastructure bill. One of them, for example, is about $38 million in federal funds for transportation electrification infrastructure. And obviously there's got to be a statewide plan. What we have in the way of the 3 plans from the investor-owned utilities is the combined surface area maybe occupies, maybe 20% of the state surface area. And so there's no doubt that the rural electric co-ops will be engaged, and it's critical for this statewide plan to integrate the current plans that we have all approved for the 3 investor-owned utilities. So there's, I think, a clear, immediate example where we can come to the table with a clear need for coordination going forward. So I just wanted to throw that out, that there is a specific example where we can begin to engage with the state agencies and the special appointed officials that are working on water infrastructure, infrastructure in general, and broadband. All right, we have a motion on the floor and a second. Any further discussion? Russell, roll call vote, please.
Commissioner Fishman,
Aye.
Commissioner Maestas,
Aye.
Commissioner Hall,
Aye.
Commissioner Vicente Aguilar,
Aye.
and Commissioner Byrd.
Aye.
Mr. Chairman, the work plan is adopted unanimously 5-0.
Thank you, Russell. And that concludes our agenda for today. Any other final comments from any commissioners? Anything else? If not, we are adjourned. Thank you all.
Thank you.